Hey everyone, I'm Diana Davison, an advocate for the falsely accused and wrongfully convicted. I go to actual trials with people who have been falsely accused, and I'm going to start sharing that knowledge with everyone more effectively. For all the people who contact me for help, there are many more who I can't reach, so this series of videos in 2020 is for them. There is a donation link in the video description so you can help me continue my work. YouTube demonetizes all my videos, and I'm crowdfunded, so I count on your donations for support. I'm going to start by explaining rape myths, and a term I've used in the past, twin myths. The twin myths are basically the core of rape shield law, and you have to know them to understand what type of evidence is not admissible in court, and why. So, we all hear the phrases rape myth and victim blaming thrown around every time someone is acquitted. I'm going to start explaining rape myths by looking at the ones that are real first, and then we'll look at how it goes wrong. I'll be going through actual court decisions to help both explain and illustrate. Though the case law and terminology is from Canada, the same principles apply in other countries. There is a core starting point to what is blocked in sexual assault trial defense arguments, and in Canada it's called the twin myths. People keep pulling more myths out of their butts, but I want to explain the basic principle accepted by all legal professionals, including defense lawyers. The two cases I'm going to talk about today are called R versus Seaboyer and R versus Goldfinch. In Canada, R is Regina, basically the state versus someone, but for simplicity I'm just going to call Crown prosecutors the state, because they work for the government and it makes it more universal. The decision R versus Seaboyer was delivered by the Supreme Court in 1991. It was in conjunction with another case called Game, but everyone just calls it Seaboyer. So in future, when I mention Seaboyer or the twin myths, this is the video that you need to watch. In this case, the Supreme Court threw out the former rape shield laws, saying that they went too far, blocking legitimate evidence and risking wrongful convictions. The Seaboyer case involved the accused not being allowed to introduce evidence of prior sexual activity between the complainant and another person. Seaboyer successfully argued that because evidence of bruising was being introduced by the state, the injuries could feasibly have been caused by the other recent sexual encounter that she'd had, and blocking him from adducing that evidence denied him a fair trial. Supreme Court basically decided that every case needs to be decided on its own merits, and blanket denial of evidence just because it's prior sexual history violated the right to full answer and defense. The main phrases you'll need to understand are prior sexual history, probative value versus the risk of prejudice, and subject matter of the charge. Subject matter of the charge means the events directly tied to a criminal charge. There will often be peripheral issues, like how long you've known each other, how people met up that night, etc. That is narrative evidence, but it's not the subject matter of the charge. This is very important because quite often it's impossible to prove or disprove what happened behind closed doors. So a lot of evidence in trial and exposing inconsistencies from the complainant will be on peripheral issues. Additionally, sexual activity leading up to an alleged offense is increasingly being called prior sexual activity, even if it happened on the same day. But for now, let's just agree that what happened a day before or a day after is not the subject matter of the charge. Prior sexual history is any other sexual activity not related to the subject matter of the charge. In Canada, that has now been expanded to say any activity of a sexual nature, which includes flirtation and includes behavior after the subject matter of the charge, and we'll get to why later. Probative value versus risk of prejudice is an assessment made by the judge as to whether or not the evidence defense wants to use has more probative value, meaning it can help to understand a live issue at trial, and if it's relevant, does the value of that evidence outweigh the risk of prejudice? They want to make sure that the evidence isn't just being used to smear someone, be it the complainant or anyone else, and it's otherwise known as bad character evidence. So the twin myths are fairly universal. This is a phrase used in Canada that may have another name elsewhere, but it's the foundation of rape shield law. The two arguments forbidden in legal argument or reasons for judgment are this: that unchaste women are 1. More likely to consent to sex, and 2. Less worthy of belief. Basically, it's the rejected argument that someone's a slut, therefore they shouldn't be believed, and that sluts will sleep with anyone, so they probably consented. This also goes to the need to understand that no one can give advance consent to a sexual act. That's another case, and I'll deal with that separately. But for this reason, all the people who think they can sign sexual contracts for BDSM purposes, or that getting someone to text you or go on camera saying they consent before you have sex will somehow stop you from being accused, well, that's wrong. It doesn't matter if you're married, it doesn't matter if you had sex the exact same way every weekend for 7 years. You can't use that to prove the person consented at the time they're alleging they were assaulted. But you might be able to use that to argue that you had an honest belief in consent. And that again is a whole separate video. As long as the probative value of your evidence isn't outweighed by the risk of prejudice, then you'll probably be allowed to use it. There are many other things being called rape myths, and some of them are also accepted in law as a myth, but the twin myths are the actual basis of the absolutely rejected lines of argument. So how can this go wrong? Well, what is happening in court is that applications to use sexual evidence in court must be explicitly tied to specific statements or issues that arise from the prosecutor's case. In a 2019 decision, Supreme Court of Canada sent a man back to trial after he was acquitted because the jury was allowed to hear the statement in R versus Goldfinch that Mr. Goldfinch was friends with benefits with the complainant, and that implied that their casual sexual relationship made her more likely to consent. It was not just deemed to be common sense that knowing the nature of the relationship was part of the narrative and understanding what happened that night. For my American friends, you did not mishear me. A man who was acquitted was sent back for retrial. In the next video, I'll explain why it is that Canada thinks it's not double jeopardy to do that. In the meantime, remember to hit like and subscribe for notifications. And don't forget to donate. My work just helping with cases going to trial is 7 days a week already, and every dollar is going to good use.